We remind the Inspector General that the principal function of the police is to provide security, not to attend trainings at the expense of effective performance of duties. Any operations or administrative processes that may affect the security of the Chief Justice must be premeditated, well-structured, and communicated to ensure smooth transition where any is required. On the withdrawal security of the Chief Justice and on the Supreme Court's decision on the ban of the advocates working under Ahmed Nasir's law firm. So I'll start with withdrawal of security of the Chief Justice, the Honorable Martha Koome. The Law Society of Kenya has taken note of the letter from the Chief Justice, the Honorable Lady Martha Koome, addressed to the Cabinet Secretary for the Ministry of Interior and the Inspector General of Police. By the said letter, the Chief Justice revealed a concerning decision by the National Police Service to withdraw the security detail attached to her office and apparent weakening of the Judicial Police Unit. We condemn this unfortunate move and confirm that whether by omission or commission, the said situation is unacceptable and indicates grave systematic and administrative lapses within the National Police Service. From the onset, we point out that the Constitution of Kenya 2010 establishes firm, elaborate, and independent institutions whose mutual understanding and interdependent operations provide a lasting safeguard for good governance for the people of Kenya. Importantly, the Constitution contemplates three distinctive arms of government of similar status and priority to ensure the ability to uphold necessary checks and balances. The mistaken perception that the judiciary is subordinate to the other arms of government is a historic bastardization of the principle of separation of powers, which must be deconstructed. The National Police Service is established as part of the organs of the national security, which must serve all people and institutions equally and without prejudice. This habit of the service operating as an appendage of the executive, giving undue credence to the superiority of the executive over the judiciary, is an unacceptable relic. The complaint raised by the Chief Justice indicates an insufferable failure on the part of the National Police Service, which must be rectified promptly and action taken to prevent such reoccurrence. While we note that an explanation has been tendered by the Inspector General of Police, it is not lost on us nor the people of Kenya that the security of an office as crucial as that of the Chief Justice is not a casual matter that can be subjected to afterthoughts and lapses in the communication or coordination. We remind the Inspector General that the principal function of the police is to provide security, not to attend trainings at the expense of effective performance of duties. Any operations or administrative processes that may affect the security of the Chief Justice must be premeditated, well-structured, and communicated to ensure smooth transition where any is required. Over and above the foregoing, we are apprehensive that against the backdrop of the recent unsettling cluelessness and feigned ignorance by the National Police Service on crucial matters of national security and human rights, the lapse alluded by the Inspector General, if genuine, raises serious questions on the capacity and competence of the police to safeguard the people of Kenya and fulfill their mandate. Nevertheless, the perceived trend of the police resorting to sporadic withdrawal of security of judges to intimidate them in determination of matters is a matter of public record, which the Inspector General cannot disown. This, coupled with the weakening of the Judicial Police Unit complained by the Chief Justice, is an affront to the administration of justice and the rule of law as we know it. Considering the unfortunate attacks on judges and magistrates in recent years, this combination of errors and omissions, if at all, on the part of the police appears insidious and deliberate. That trend must be nipped in the bud. We call on the Inspector General of Police, the National Police Service, to take immediate action to address all issues relating to the security of the judiciary. Our constitutionalism is dependent on a fully functional, unstrained judiciary working to administer justice and ensure accountability in governance. The Law Society of Kenya asserts its strong defense of the independence of the judiciary from external attacks. Thank you. So this statement is on the Supreme Court's decision to uphold the ban on the advocates working under the firm of Ahmed Nasir Abdullahi Senior Counsel. The Law Society of Kenya expresses its great concern over the Supreme Court of Kenya's decision to uphold the ban imposed on Senior Counsel Ahmed Nasir Abdullahi and his entire law firm and advocates associated in his firm, barring them from appearing before the court. This decision was first made in 18th January 2024, was reiterated on Tuesday 21st January 2025 in Supreme Court petition number E035 of 2023, where an advocate from the firm was denied audience while representing the petitioner in the matter. The conduct of the Supreme Court raises fundamental questions about judicial conduct and fairness, its broader implications for the legal profession, and the public confidence in the judiciary. Extending the ban to advocates employed in or associated with Senior Counsel Ahmed Nasir's law firm, along with their clients, infringes on the right to earn a living, the independence of the legal profession, and the right to legal representation. Disturbingly, the court has condemned the associates without disclosing any offense they may have committed against it, simply by virtue of their association. This action not only undermines the rule of law, but also denies clients the freedom to choose legal representation, a fundamental tenet of access to justice guaranteed under the Constitution. Additionally, the court's failure to utilize the existing mechanism for disciplining advocates as established under the Advocates Act further exacerbates the situation. For the Supreme Court to bar advocates from accessing a constitutional organ without proper dispute settlement processes reeks of judicial impunity, which the Law Society condemns at its strongest terms. In line with its mandate under Section 4 of the Law Society of Kenya Act, which includes protecting and assisting the public in all matters touching on law and justice, the Law Society of Kenya filed a constitutional petition number E026 of 2024 before the High Court. This petition challenges the Supreme Court's decision made on 18th of January 2024, as well as any resulting actions The Law Society of Kenya emphasizes its unwavering commitment to defending constitutional rights, including the right to legal representation and access to justice. So, as the petitioner in the High Court proceedings that were stayed in exchange for an expedited hearing of the civil appeal, number E615 of 2024, the Law Society is deeply concerned that to date, despite the assurance and the decision of the High Court judges, no hearing date has been set for the appeal, which marks of malice. Given the far-reaching implications of the continued existence of these orders, we urge the judiciary to expedite the resolution of this matter. The Law Society of Kenya is concerned about the precedent set by these orders, which threatens the principles of transparency, accountability, and judicial independence. Decisions of this nature risk eroding public trust in the judiciary and setting a dangerous standard that undermines the equitable administration of justice. Judicial power as a public trust must be exercised with fairness, impartiality, and inclusivity. While the judiciary must remain independent, it must also embrace constructive criticism and accountability. These qualities are critical to maintain public confidence in judicial decisions and ensure that judicial power is exercised in the service of justice and the Constitution. If our calls for the reversal of these orders are not heeded, the Law Society will be compelled to take further action, including mobilizing our members to stage peaceful protests and occupy the Supreme Court in protest. Advocates may also be called upon to boycott appearances before the court as expression of disapproval. The Supreme Court's decision to deny advocates audience borders on judicial impunity, abuse of office, and incompetence. This presents ripe grounds for removal of a judge, and we also urge the Judicial Service Commission to initiate disciplinary proceedings to safeguard the integrity of the judiciary. The Law Society remains firmly committed to promoting the rule of law, protecting constitutional rights, and fostering a judiciary that operates transparently, impartially, and in service of justice. We call on the Supreme Court to carefully reconsider the broader implications of its actions and take immediate steps to restore public confidence, which is its role to always be an impartial arbiter of justice. Because if unchecked, this conduct is slowly picking up in other courts within the judiciary, and we are worried on the trend that tomorrow, if you criticize any judicial decision or you criticize any judge or magistrate, you shall be barred from going into those courts. And this also smacks of clear judicial impunity. Thank you.